Okay, we're right at 4 p.m. Derek, should we get started? We have a
Yeah,
good
let's go ahead
number.
and do that.
Great, we have a good number of participants, and we are recording today. It's February 15th, 2024, and this information will be available on a later date if you happen to be watching later. We're back. Derek and I are here to talk about some of Derek's favorite topics, death and taxes. We hope that we'll be able to provide some insight into different types of taxes that may be involved and give you some ideas about how you might incorporate tax planning strategies into your estate plan. I have a quick legal disclaimer for us today. The content that we're providing in this webinar is for informational purposes only and is not intended to be legal advice. We are providing information that may not apply to your specific circumstances, and we strongly recommend consulting a qualified attorney to advise you on your individual situation. If you have any specific legal questions or require personalized advice, we invite you to give us a call, schedule a consultation. Hopefully we can be that qualified attorney for you. Now that we have the disclaimer out of the way, I was hoping, Derek, that I could tell a joke.
Please do.
Here's my joke. What's the difference between death and taxes?
What's the difference between death and taxes? You only die once, maybe?
Maybe. The answer I have is Congress doesn't have the power to make death worse.
Good one. Excellent.
Okay, we have today the Q&A opened up for those questions you might have during the meeting. So feel free to use the Q&A. Hopefully we'll have time at the end of the presentation for the question and answer portion. Okay, so Taylor's helping today with the slideshow. We're going to start off with state-specific taxes. Thankfully, in Washington State, we don't have an inheritance tax. There are 6 states in the US that have an inheritance tax. And that is a tax imposed on the value that somebody receives as an inheritance. So the beneficiary is liable to pay that tax, and the tax is imposed on the receipt of the inheritance. We don't have that here in Washington. There are a number of states that do. But in Washington, we have the estate tax. It's our own version of the estate tax. There are 12 other states which have this state-specific estate tax. Every state has their own exemptions, slightly different rules for those. Washington, D.C. also has the estate tax. Estate tax is imposed on the value of the decedent's estate at the time of death. So it's fair market value of everything somebody owns at the time of death. And the tax is paid by the estate rather than the beneficiaries who are receiving inheritance from the estate.
That's right. And you could have taxes in multiple states. If you have property in multiple states, you may have, even though you do not reside in all the states, you could still be subject to taxes in those other states.
That's right. So the calculation of the tax may depend on whether you are domiciled here in Washington at the time of death. So you're considered domiciled in Washington if this is your permanent home here in Washington. And if that is true, then all your tangible personal property, which is located here, and all of your intangible personal property, so all your financial accounts are taxable here in Washington State. Real estate, of course, that is located in Washington is taxable in Washington State. If you are not domiciled here in Washington at the time of death, then only your real estate or any tangible personal property which is located here in Washington is taxable at the time of death. And there is an apportionment. So if you happen to own real estate in different states, maybe you have a vacation home in California, the tax is imposed on the entire value of your estate, but you do get an apportionment for that out-of-state property. So we include everything you own at the time of death, fair market value on date of death. The Department of Revenue wants you to calculate the tax on 100% of the net worth. At the time of death, of course, you need to include any proceeds from life insurance if you owned a policy at the time of your death. But if 20% of your net worth is located in California, that's your vacation home, you only pay 80% of the tax because 20% was located in California.
And on this one, Anita, that's a very interesting point. You can convert real property into an intangible property by holding it in, say, an LLC or a business entity. So you may have a rental property in Texas, and you're saying, and it might be very valuable, but it will actually be taxed here if you hold that in an LLC because it's now an intangible property, even though it's the asset inside the LLC is real property.
Yes, although there may be an exception for single member LLCs or a disregarded entity LLC that's owned just by a married couple. Okay, do we have what's our next slide, Taylor? We have the tax rates and the exclusion amounts. So Washington State estate tax is a progressive tax. First $1 million over the exempt amount is taxed at 10%, and it graduates up to a rate of 20%. The tax is imposed on every dollar over the exempt amount. And on the right side, you see what is currently the exempt amount. So it has changed since 2020 or since 2006, but very gradually, and it's remained the same since 2018. So I did pull up my inflation calculator, and it looks like the value of 200, or I'm sorry, the value of 2,190,000, I can't say my numbers. What's the value of the $2.1 million in 2018 calculated to today's value? So everyone knows we have very high inflation currently. It's about 2.7 million. So we often hear that this is not adjusted for inflation, and this is a broken system. What would you add to that, Derek?
Well, I think that's absolutely right. We can go back, a few years ago, and 2 million or 2.2 million may have seemed like a lot of money, and there's quite a few people who may not have had to worry about estate tax planning at all. And now, as their assets have gone up, they're now wealthy as far as Washington State is concerned, and they should be paying estate tax. I also would note that the tax rate brackets have not adjusted for inflation. So, what was $1 million, levels back in 2006, for example, those don't feel nearly as large anymore. That $1 million. So people are hitting those higher brackets faster, I think.
And then we have the federal gift and estate tax as well. So a similar type of system. It's also a progressive tax. It's imposed on the value over the exemption amount. So every dollar that exceeds the exempt amount. This year, the exemption is very high. We have a $13.6 billion exemption. I think back when Derek started practicing tax law, I looked it up. He graduated from the LLM taxation program in 2003. back then, the exemption was only $1 million for a federal gift and estate tax, and the top tax rate was close to 50%. Today, we're at $13.6 million, and the top tax rate is 40%. Maybe you could speak to the predictions, Derek, for what's going to happen next year and beyond. So this rate, the exemption is always changing.
That's right. As we're looking at 2025 there, we see a bunch of question marks. And I will say that the big jump you see that started under President Trump back in 2016, when they kind of adjusted, or they made the tax law then. I guess it shows up there as 2018 as the big jump, and when it doubled. But that is scheduled to be repealed or go away in 2026. So we could see that federal exemption get cut in half. Of course, if you haven't noticed, we are in the middle of a presidential election year, and generally we see a new tax bill that comes out the year following or the first year of a new term for the president. So we would expect an estate tax bill to be coming out in the first part of 2025. And it will probably adjust or be directed to that exemption. So we don't know. It could go down. It could stay the same. I don't really know where it's going to go for sure. If you could tell me who's going to be president, I'm not even sure that would help us at this point. So we'll see what happens. But what it means for planning is we need to go. We're really having an area of uncertainty. So if you have a larger estate, we shouldn't really be relying on a $13.6 million exemption going forward. We need to think about what we should be doing now to address that.
And what would happen if Congress doesn't make any action and there is no change in the tax law?
Well, that's right. So then we would end up getting it cut in half. So we'd be looking at maybe a $6.8 or $7 million exemption for each spouse. And at the 40% bracket, that difference for a married couple who have a larger estate like that could be 5.6, maybe $6 million worth of additional tax by losing that extra exemption.
I think that's a good segue into the next slide, the bypass or credit shelter trust. On the federal side, we do have portability. So a deceased spouse's unused exclusion amount can be ported over to a surviving spouse. This only works for married couples who are U.S. citizens. But there's an easy way to save the deceased spouse's unused exemption. You file that estate tax return and you elect portability. In Washington state, we do not have portability. So even though each one of us has the $2.19 million exemption that we can pass without estate tax, if we give all of our assets, if I gave all my assets to my spouse, for instance, at the time of my death, then I've kind of wasted it on him because we've now put all of the marital assets into one person's name. So there's a higher likelihood that there will be a bigger tax burden at the time of the second death. Maybe he'll spend it all and or give it away in advance. But what we want to avoid is to put all the marital assets into one person's name. And one method to plan for this is the bypass or credit shelter trust. This does need to be included in an estate plan before the first death. So this works for married couples. And in the estate plan, instead of having all the assets go directly to the surviving spouse, instead we would carve out a tax exempt portion. In Washington state, it's up to currently $2.19 million, and that would be set aside in a credit shelter or bypass trust. The surviving spouse can still manage the assets there, can still control the investments. We typically allow the surviving spouse to use those assets if necessary to live out the remainder of his or her lifetime. And we can include descendants as beneficiaries there as well. If kids need money for college or living expenses, it's permissible to use those funds. But the amounts in the credit shelter trust can accumulate, appreciate in value, and it should pass estate tax free to the children or to the ultimate beneficiaries after the second death.
So, and I would add here that, bypass or credit shelter trust are some of the names that are used for this kind of a trust. If you're looking at your documents and you're wondering if that's in fact what you have, you may not actually find these names in there. You may see a statement in there about a disclaimer trust. Sometimes this has been called a family trust. So it may be a little bit hard to know if that's what's happening in your plan. But if you see a provision that says that it's not going directly to your spouse, if there's a complicated formula in there or other provisions, that might mean that you have this kind of a trust in place in your planning.
Okay. I think this is a good slide for Derek.
Yeah.
If you'd like to discuss Q-tips and Q-dots.
Oh, yeah. So what ends up happening here is, what about amounts that are above and beyond that exemption? What are we going to do with those? Sometimes you will want to have some extra control on those as it's going to your spouse. It could be you each have your own assets. You could each have your own children. Those are kind of traditional reasons that this has become an issue. And the idea would be that you'd like to make that gift to a spouse, but you don't have enough exemption to cover it. And so this would actually be what we would traditionally use a Q-tip trust for. And so you could make a gift to the spouse in a trust, but for estate tax purposes, it would be included in the surviving spouse's estate. This allows us to defer the taxes on that, but still allow the first spouse to die to have some control over how that property is used during the spouse's lifetime. The provisions of a Q-tip there are some that are required. For example, only the spouse can be the beneficiary. 100% of the income that's created by the assets in the trust must be paid out to the surviving spouse. Are some of the required provisions to be in there. However, we also have other reasons we might need to have a Q-tip trust. For example, if we have a non-citizen spouse, and Anita did mention this, a non-citizen spouse does not automatically qualify for an unlimited marital deduction. So instead, we would need to put that into a special kind of trust called a Q-dot. And so it is a trust that has some additional provisions on it that will control whether or not that trust will be taxable at the first death. And we can defer taxes even if the gift is to a non-citizen spouse by using one of these Q-dot trusts. And for any estate then that would have, for any spouse who would have, if their spouse is a non-citizen spouse and their estate is greater than the 2.2 million, meaning that we're not going to be able to protect it all from estate tax using the Washington state exemption, then we would need to have that Q-dot trust in there. So for a married couple, you can start thinking about when your estate is up over 4 million, getting closer to 5 million, you're definitely going to be wanting to have this type of provision in there if you have one of the spouses who are not U.S. citizens. And I think that's kind of where these trusts come into play. They're very important, however, when we're doing our estate tax planning.
So these two strategies, or the few that we've discussed so far, work well for married couples. What about people who are not married? What kinds of strategies might we employ there? Derek likes to use a gift later plan. Let me talk about my favorite plan, though. That's to spend your money before death. So that's the advice I like to give my clients. Make sure you stop flying coach, get those first class tickets, take all your friends to see Taylor Swift. Make sure you spend your money before you die. If you don't own it anymore, it's not going to be taxable at the time of death. Oh, we're adding to the slide. Spend now. Gift later works too. It's not quite as fun, but I think lifetime gifts can be fun because you get to see, the joy you bring people or the way people are making good use of those gifts. For gift later plans, we're going to be using potentially powers of attorney or language within a trust agreement for a successor trustee to make those gifts. Of course, if you're capable of making those gifts yourself, that's great. But oftentimes at the end of life, there are incapacity issues, and a person may no longer be capable of making those transactions or contemplating lifetime gifts. So we want to make sure that the power of attorney document is a general durable power of attorney, and that it's going to allow for more substantial gifts. I recently reviewed a power of attorney document that it's a typical one that it is according to Washington state statute, and it only allows for gifts up to the annual exclusion amount. This year, the annual exclusion is $18,000. That's not going to get you very far in terms of reducing the size of your taxable estate. I think we're skipping around. If we could go back, Taylor, I think there are a couple points there that we missed. But just to mention that the current annual exclusion is 18,000, and you're going to need a lot of friends before you can, make that stretch enough to reduce the estate tax liability. For instance, if somebody had a $4 million estate and we're trying to get it under that $2.2 million threshold, they're going to need to make 100 different $18,000 gifts. So better make a lot of friends really quick because each recipient, each donor can give up to 18,000 per year under the exclusion. Of course, you can make bigger gifts. And that may be a good strategy. I think you have a little preview onto capital gains planning here, Derek. Can you speak to the married couples?
Oh, that's right. So gift later, when would you make those? The question is, when's the optimal time to make those gifts? And people always know about the step up in basis, or it's one of the benefits of dying, I guess, if there is such a thing, at least in the tax code. And that's code section 1014. And we'll talk about that a little bit later. But if you're thinking about real estate or other capital assets that have a very low basis, the best time to gift those is to gift those after the first death. If those happen to be community property, they would get a full step up in basis. And now they could be gifted to the children or to other beneficiaries, and could be sold at any time without that all that built-in capital gains that had been there. So that's the most tax effective time to gift.
I think we're ready to move on to the next slide. Great. So as we mentioned, $18,000 is the current exclusion amount. That doesn't mean that you can't gift more than that. It just needs to be reported on a gift tax return if the gift is larger than the exclusion amount. We had some clarification from the IRS back in 2019. The current exemption is over 13 million. So what if Derek wanted to give me $13 million this year as a gift? Thank you. What would happen if he did use his entire exclusion amount? What would happen in 2026 when that exclusion potentially goes back down to 5 or 6 million? I think the IRS did clarify that.
Yeah, that's right. So there was a lot of discussion among tax professionals about how this would actually be impacted. Would we now somehow have to go back and recapture that tax later, maybe at someone's death? But no, in fact, if you do gift above and beyond, where the exemption eventually goes to when it gets cut in half, that's a freebie. It's outside of your estate. So there's a lot of planning that people are doing for considerably larger estates where they are gifting those full amounts. They want to gift that full amount. I will point out that this kind of works against us in some ways, in that what we would really like is that you are gifting from the top part of your exemption. So if you have 13, if you could think about there being a part A and a part B of your $13 million exemption, and the part A is, say, the 6.5 million that you're still going to have in 2026, and the part B is the other remaining, the 6.5 million that you have right now that's going to go away. What we'd really like to do if we were gifting in 2024 is we'd like to gift from that part that might go away, so we'd still have our part A, our 6.5 million. But that's not exactly the way it works. From the IRS's perspective, they actually take it from that 6.5 million, that part that you're going to still have in 2026. So unless you're willing to do a gift greater than half the exemption, so about $6.5 million, $7 million, you may not get a lot of benefit from doing, being too worried about this 2026 number when the exemption comes back down, because you really would need to make larger gifts greater than half the value of that exemption before it would make a big difference on your federal estate tax issue.
So what if you're not ready to give an outright gift? What are some trusts that you might use, or different ways that you might structure gifts, Derek?
Well, of course, we love trusts, and trusts really provide an opportunity to split the ownership, the management, and the benefit of assets. And you can do this for many different reasons, and there's many ways that we can do it. One of the ones that is very effective and is something to consider is for an irrevocable life insurance trust. Life insurance, unfortunately, the death benefit is taxed in the estate, even though there's no income tax on those dollars. So you end up, a portion of your premium dollar that you're paying every year is essentially going to pay estate tax if you have a taxable estate. You can get more efficiency then out of your life insurance by owning that policy in an irrevocable life insurance trust. It's not that life insurance isn't really doing a heck of a lot for you until death anyway. So why own it in your own name and potentially be taxable on that? So that's a kind of an easy one. When we see life insurance in an estate, it's one that we like to move on over into those ILETs. The Spousal Lifetime Access Trust, I think, is ideally suited for Washington State. It can allow you to make those larger gifts so that you can bring your estate down to below the Washington exemption to your spouse. So you're actually making a gift to a trust for your spouse, but it'll be excluded from your spouse's estate. It'll also be excluded from your estate. And really, if you think about it, we could gift the full $13 million exemption. Both spouses could do that into something like this Spousal Lifetime Access Trust. They would still have their $4.4 million of Washington State exemption. So truly, a $30 million estate. If you had a $30 million estate, you could avoid Washington State estate tax using that tool. But often it's just going to be a simpler trust. I do list out a couple of specialty trusts here for how we deal with income taxes, the income defective grantor trust and the beneficiary deemed owner trust. Those are addressing something we'll see a little bit later, and that is that trusts generally have high income tax rates inside of them. Not the rates, excuse me. The brackets are very small. So once you're over about 15,000 of income, you're actually in the highest income tax bracket. And so we do want to manage the income taxes inside a trust that we're using for gifting. I listed out here a dynasty trust, really for generation skipping. So you can create a trust that's going to last for multiple generations and really have funds that will be outside of the estate tax for over and over, for many generations. My last one I listed was a non-grantor irrevocable trust. And this one is really, I think, very specialty. This would be something that we'd only use to address the Washington state capital gains tax, which is a subject that's coming up a little bit later. So we can talk about how this trust might help with that at a later time.
I think it's just on the next slide here, so we don't have to wait too long. Capital gains is our next topic here. The step up in basis means that any assets that are part of a deceased person's taxable estate gets the basis adjusted to fair market value on date of death. But remember, it's a basis adjustment, so it's not necessarily a step up in basis. It could be a step down in basis. From a pessimistic point of view, that does happen, but oftentimes you have investments or stocks that a person has owned for many, many years and that has highly appreciated. So that's a great way to save on capital gains tax, hold on to that asset until the time of death, and the basis is adjusted. Of course, there is no adjustment for any gifts that you make during your lifetime. So gifts get a transferred basis. The recipient of the gift will have the same cost basis, and there's no adjustment for any assets that you've already gifted away during your lifetime. We are fortunate in Washington to be a community property state because that means if a married couple owns a home, for instance, a community property, the entire basis, both halves of the community property, is adjusted to fair market value on date of death. So if your parents have been living in their house for 30, 40 years, they probably have a very low cost basis there. All of that, the entire house is adjusted to fair market value on date of death, even if one of the parents is still living. And I think Derek was excited to talk about the new Washington state capital gains tax that was effective as of January 1st, 2022. So brand new tax here in Washington.
You bet. And it is a new tax. And if you've been following it, made it all the way through the Washington State Supreme Court. It's been challenged. Our state constitution says we can't have an income tax. And so they categorized this as an excise tax. And that's primarily what was being challenged there. One of the things that it is unique about it right now, at least, is it does have a deduction of currently $262,000, as Anita has noted here. Real estate is not going to be included in that. Interest in privately held entities, if the capital gain is directly attributable to real estate. So there can be ways to keep even real estate that's been held in an LLC or something out of this. But most other types of stock, private stock or business stock or stock options that you've received, or stock that you received as some from work or whatever, those will be considered subject to this tax. And I don't know if anyone has been. One way to address this is you could take the Bezo plan and head out and move to another state, and that's what he recently did when he sold, I think, $4 billion of stock and was able to avoid having to pay the Washington state capital gains tax on that. So that's one way around it. I will also say that the definition of capital gains here is actually tied to the U.S., the federal income tax calculation. So it does get a basis step up. So here's a nice little feature. So if you did have a significant stock holdings at the time of death, not only are you going to avoid the federal estate capital, excuse me, the federal capital gains tax due to that basis adjustment, you would also avoid the Washington state 7% capital gains tax on that. So really, for those larger portfolio holdings with significant amount of capital gain in them, we can think of that as a 27% tax that we could get protection from. One of the questions that actually came up this week was, hey, what about trusts? Because it says in the law that trusts are, this is for individuals, but not for trusts. And that's true, but your normal revocable living trust is a grantor trust, and it will be, if property sold in that, yes, in fact, you will need to still pay the Washington capital gains tax. Now, you could use this, and I mentioned it just the last slide, the non-grantor irrevocable trust. So you could make a gift to a trust. It's a non-grantor trust, so that means that it's going to be taxed at the trust level, and then those shares could be sold. And if they were sold at that time, they wouldn't be subject to the Washington capital gains tax. Now, mind you, they would still be subject to the federal capital gains tax inside of the trust. And there's also the Affordable Care Act surtax inside of the trust. So you get some tax savings, but maybe not as much as you'd hoped. But that is an available option, and I suppose in the right circumstance, it could be used.
I did promise to be monitoring the Q&A. We have one relevant question from Alex here. He's wondering if stocks are owned in a joint account with the spouse, how much of it gets a basis adjustment?
Well, and if it says if it's held by husband and wife, one account that's joint, there's a presumption in the law that that's community property. But you can actually have an agreement as to whether it's community property or not. And otherwise, you'd have to kind of trace back and find out the sources of it. So the favorite answer of an attorney, it depends, I suppose. But the likelihood there is that it would be considered community property.
That ties into our next slide, the basis adjustment on community property. I think we touched on this, but what happens to Q-tip property, Derek, if that deceased spouse's assets are held in a Q-tip trust? What happens with the basis there?
Well, that's right. So this was actually the subject of a tax court ruling here. Gosh, I think last year I got a few questions on this. And the question really is, if it's an irrevocable trust and it is, outside of your estate, would it still be subject to or still be eligible for a step up in basis? And there was, a very prominent attorney who was arguing that, yes, in fact, it should still get a step up in basis because the step up in basis provision is related to income taxes. And if that irrevocable trust happened to be a grantor trust, was designed that way, then it should get a step up in basis. Most of the other attorneys kind of said, well, no, that doesn't make any sense because it's excluded from your estate, so it shouldn't be eligible for a step up in basis. And that ended up being what the ruling said. But that does leave us this question of this Q-tip trust. So a trust that you create for your spouse, since it will be included in your spouse's estate, the Q-tip trust would be at their death, it would be eligible for a step up in basis. And so this is a good way to really get a double step up. You get a step up at the first death. There could be significant appreciation of those assets, and then you get a step up at the second death also. And so that was really the point I was trying to make here on this slide. And I will also say, kind of going back, I suppose, to the last question you just had, community property is an interesting subject and is one that we actually really work a lot with in our office. But you can have an agreement between spouses and describe what is community property and what is not community property. And that can be very useful then to obtain the best tax results when you're doing estate tax planning.
We're ready to talk about taxation of retirement accounts. So now we're on to the topic of income tax. The distributions from certain retirement accounts are subject to income tax. Those would be your 401ks, 403bs, or traditional IRAs. And those distributions are taxed at the plan participant's ordinary income tax rate. So that the answer is simple. But what happens if someone inherits an IRA? So we no longer have the plan participants income tax rate, and the person who is receiving the distributions from the retirement account would be subject to income tax in those instances. We have another slide that details those income tax rates. Yeah, so go ahead, Derek.
Yeah, and this one I was just trying to show, one of the ideas is for estate planning is where do we direct that retirement account? Do we direct it to individuals? Do we direct it to trusts? And this is what I was just trying to show here is how fast we get into those high brackets with a trust, and that would be for dollars that are held or accumulated inside of the trust. So you could have the funds from a retirement account get paid out to a trust, and then that trust may not distribute that money that year. And if it doesn't, then it's going to be income taxable inside the trust. And if we're talking about 10% of the value coming out in a year, for example, and there was $1 million, you got $100,000 coming out, and it would be taxable. A big chunk of it would at that 37% tax rate. And so those aren't the best places for preserving the value that's been built up inside those 401ks by having those go into trust. And so we are careful then in our estate planning of where we're sending those retirement accounts. Does it make sense to have it go to like a bypass trust or credit shelter trust? Does it make sense to have it go to a Q-tip trust or to the spouse directly at the first death, or then at the second death, or at death of a single person if it's going off to the beneficiaries? We can also think about what rates they're at. So I didn't have it on here, but if you have your beneficiary happens to be in California or in New York, in addition to these rates that we're looking at here, you can add on their state income tax rates too. So these dollars that were really earned by you while you lived in Washington that doesn't have an income tax could potentially be subject to estate taxes at your death, depending on the size of the estate. And then as those dollars are coming out of those retirement accounts down to your beneficiaries who live in California, they're having to pay at their tax brackets, whatever tax bracket they happen to be in, plus these dollars are coming out to them at those tops of those brackets, those marginal rates. And so if they're a high earner, they might be in a 35% or maybe even a 37% bracket. And so a big chunk of those dollars is going to the income taxes also, plus whatever the state's charging. Down in California, it can be over 50% combined state and in federal income taxes.
I think from an income tax perspective, it's best if the surviving spouse, if you have a surviving spouse who can inherit one of those retirement accounts, would you ever include a trust as a beneficiary on those accounts? What instances would that be appropriate?
Well, absolutely. What if we have a minor beneficiary? That those accounts are going to need to be managed. And what if, or even if it's somebody who is not a minor, but still needs someone else to be managing it for them. So that, a 21-year-old, a 23-year-old, that might make more sense. We can also still use it for the surviving spouse. There's some special rules for that, and have it go to that Q-tip trust. We don't do that as much because we tend to, like the ability to get that rollover and have the deferral happening inside that retirement account for a longer period of time. But there are definitely reasons and ways that you can direct a retirement account to a trust.
We're always considering tax rates. But also, what is the length of time when we can, throughout which we can spread out those distributions? So if you paid out an entire 401k in 1 year, that would push somebody into maybe a very high tax bracket. So one of the strategies would be to spread it out over as long of a period of time as possible. But with the new Secure Act, we no longer have the ability to stretch those IRAs over the beneficiary's lifetime necessarily. You have a slide here. We have some comparisons between Secure Act and Secure Act 2.0.
That's right. So this was something that came along in 2020, and I think it would have been big news and everyone would have been paying attention to it. But if you recall, we had something else that happened at the beginning of 2020 that kind of caught the world's attention. Otherwise, I'm sure the Secure Act would have been on everyone's mind. The big change here really is, from an estate tax planning perspective, is that we no longer can have that stretch IRA. That was a really nifty tool because we could direct an IRA to a younger beneficiary, say in their 30s, and it might be able to be distributed out over a 60-year period. And how fabulous would that be to have it coming out at such a slow rate, a lot of great income tax benefits from that. But with the new Secure Act, then that has to come out over a 10-year period. And so that's going to be accelerated. And from our, when we're looking at the rates there, if your beneficiary happens to be in their highest and best earning years in their 40s or 50s, and they happen to live in California, yeah, those dollars are going to be coming out to them, and they're going to be paying really the highest rates that they'll be paying their entire life, likely, on those dollars as they come out. So it's a bit of a problem for our clients who have larger amounts in those retirement accounts, $1.5 million, $2 million, $3 million, whatever it might be, because those funds will be coming out at very high rates. One of the other things that did happen here on the Secure Act is it did push up our retirement age, or the required minimum distribution age up to 72. The Secure Act 2.0 pushed that up a little farther, up to 73, and it had a few other little adjustments. One of interest there that I think we're still looking at is the conversion and rolling over of 529 plans into Roth IRAs, and that looks like something that could be very beneficial to some people. And so we'll kind of follow that here in 2024 and see how that works.
Like we have a question from Robin about inherited IRAs. She says that she believes that inherited IRA, you would pick up the same distribution schedule as the deceased person. So the annual disbursement to the inheritors the same as the plan participant. Is that still true, Derek, under the Secure Act rules?
Yeah, we don't have all of the rules up here, but there are some particular rules. For example, if the beneficiary is under 18, we don't have to start distributions on that 10-year schedule until they're 18. The spouse will have a couple of options. They will have an ability to take it on a longer table, or they could take over the distribution plan, or really from the deceased, whoever was deceased. And so that can also be for an option if we've already started our required minimum distributions prior to death, then we would have that option to extend it out over the I guess what would we call it? We would call it the hypothetical life expectancy of the deceased person, that's used on that table. So we could stay on that participant table and make the distributions that way.
And there are certain beneficiaries who are considered eligible designated beneficiaries. Those would be people who are disabled, chronically ill, not more than 10 years younger than the IRA owner, or a child of IRA owner. I think the IRS regulations did clarify that the age of majority is 21 because the statute didn't define it as 18. But these are still all new rules, so they are subject to clarification. So those eligible designated beneficiaries do get some special treatment, but for the most part, most beneficiaries would be looking to make all the distributions, have all those paid out within a 10-year period. Okay, I think that gives us a few more minutes for questions. We did get to some of the questions that trickled in. Do we have others from previous slides? Let's see. So Robin's also asking if your estate isn't well over 6.5 million, is it true that you should not worry if the exemption amount in the federal estate tax goes lower?
Yeah, I mean, I think you still could have a Washington state estate tax issue. But you know, you're not getting an extra benefit by gifting now. I mean, if your estate's less than the $6.5 million exemption, if you gifted $2 million right now, you would have a $4.5 million exemption left if it goes back down. So there's not, you haven't really made a big difference other than I suppose if that property can appreciate in value, it's been gifted. So right. One of the techniques we do use is an estate freeze. I'm sorry, I'll continue on that. So one of the ideas we do use is an estate freeze. And so the idea would be to use the gifting ability to move it out of your estate currently so that it appreciates outside of your estate. And that appreciation then will escape estate taxation. And so you might have it come back into your estate, or a portion of it come back into your estate later, or there might be a way to swap it or do something else with it. But if you can use that exemption to move that appreciation out, because even if you had a $6.5 million estate right now, it might be worth 10 million or 12 million, you know, in a few years. And so if it grows faster than inflation, then you could still have an estate tax issue in those later years. And so it might make sense to do the gifting for that reason, I suppose.
And how do you solve for that capital gains tax issue if the asset does appreciate highly between the time you gifted it over to an irrevocable trust, say, and then the time of your death?
Yeah. So often we will use one of those income defective grantor trusts or a SLAT for that transfer to move that value out of the estate. One of the ways that you can make it a grant or trust for income tax purposes is to include the ability to swap assets or to reacquire an asset. So essentially you could buy that asset back and buy it back on a promissory note, for example. You would have the value would be in your estate. It would be eligible for a step up in basis now. The note would actually be a liability in your estate. And essentially then you're getting an opportunity to get a step up in basis on that asset for that appreciation that occurred outside of your estate. So in an example, say it was, you know, a $2 million portfolio that you moved out of the estate. Maybe it was a single stock that's appreciated very well. You reacquire it with a $2 million, you know, it's now worth $4 million. You buy it back essentially from that trust for a $4 million promissory note. At your death, it's worth $4 million, but we have a $4 million liability against it, so it really looks like nothing in your estate, and your estate owes that $4 million back to the trust. And so that's kind of the way you can do it, and you can do a lot of variations on that and a lot of different ways to get to that. So.
We have a couple more questions here. Steve says that his broker mentioned disclaimer trusts as an option to consider. What are your thoughts on disclaimer trusts, Derek?
You know, we used disclaimer trusts extensively, I think 20 years ago. they make a lot of sense when the estate is right around the value of the Washington state exemption. However, if the estate is larger, there may be more efficiency using more of a formula clause and more of a a set calculation on how we're going to get the value, the exempt value, over into that trust. Also, a disclaimer trust will have some limitations on it that are not the best for certain types of planning. So, for example, for if we have a younger couple and one of them were to die, and they might have younger children, for example, it's very likely that the survivor would live to life expectancy. And if that's 20 or 30 or 40 years later, there could be a lot that has changed in their family. They could have children that have health issues, asset protection issues, marriage issues, grandkids. And with a disclaimer trust, you're not going to be able to make adjustments on how that distribution plan is going to go out to those later descendants. Whereas a different version of a trust, a family trust or exempt trust of some kind, would give us more flexibility on that.
And keep in mind with a disclaimer trust that qualified disclaimer needs to be signed within the first 9 months after death. So it is a difficult time if somebody is grieving the loss of a spouse, and to think about making the proper tax elections, signing the qualified disclaimer. Oftentimes the 9-month period goes very quickly and that deadline is missed and you can no longer use the disclaimer trust.
Yeah.
Okay, I think we have time. Oh, go ahead.
Oh no, I'll start talking all day long if I go on that. So I'm going to go ahead and let you continue.
Okay, we have time for a couple more questions. So Robin's asking as well, how do you know how much to gift and retain enough for yourself to live until you die? That could be a tricky problem to solve.
Well, that's exactly right. I mean, and that's the reason a lot of times people aren't gifting is we don't know that number. I think a financial planner can be very helpful on that. Having a full budget, understanding what your expenses are, how much money you need. I know that when we do aggressive gifting plans, that's one of the things we're going to want to look at is making sure that we are maintaining enough to feel comfortable and not feel like you're at risk. I will also say that many of the techniques that we can use can provide access or control to those assets in a way that can provide some of that security back. So although the gift can be made, so for example, I mean, a simple one might be the use of a Cooper trust. I don't use these a lot, but this is a qualified personal residence trust. And it's a way to gift your house outside of your estate, but still you have your house and you can still live in it. And so it's a bit of an option there that sometimes can make sense as a way to move value out of the estate and still kind of maintain your lifestyle the way you need to. And so there's other tools like that we can use. It just really depends on an individual basis. But I think a financial planner could help on that if you're not able to kind of figure out your own budget and your expenses and where you're at. Yeah, we can do what we can do, but I don't know how much everyone spends either. So
it'd be great to find that person, as Robin suggests, who can give you a holistic recommendation based on your assets, net worth, and all the tax and estate law implications. I do have a couple names I could share with you, Robin, later. But since this is Derek's favorite topic, I'll give you the floor to make any closing remarks and be sure to sign up for our upcoming webinars as well.
Anita, thank you so much. You did a great job on this one today. I appreciate that. My voice is a little bit hoarse, and I feel like if I was talking much more, I'd probably end up making just be gibberish. So I appreciate you taking such a great lead here today. Yeah, this is one of my favorite topics. And it's one of those things that is constantly changing, you know, and there's new ways to look at a particular issue. We did talk about, you know, just really trying to understand where everyone is at and what they need, what they feel comfortable with, but still providing as much flexibility as possible. I've been reluctant to use a lot of irrevocable trusts in the past, you know, just because we want to make sure it can be as flexible as possible. But we've added a lot of ways to keep those flexible when we're designing those and putting those in place. This is something that we are anticipating more and more people will have interest in as we get closer here to the election, as we're looking at 2025 and then that potential 2026 year. So it is something that our office is, if you will, gearing up for doing more. It's always been a part of my practice, but it is something that, you know, we're very much in tune to and following on a national level, and then trying to also make those adjustments when we consider what Washington State is doing here. And that's really the key, I think, is understanding which taxes are out there that are going to be applying to you. You know, the federal estate tax, the federal generation skipping tax, the federal gift tax, capital gains tax, income taxes, Washington State capital gains tax, Washington State estate tax, you know, the special rules for retirement accounts, assets going in other states. It really makes your mind go dizzy sometimes, but trying to figure it all out is kind of a puzzle. And that's one of the things I do enjoy working on. So thank you again, everyone, for joining us.